Hi everyone, happy Sunday. Today I would like to talk about partner visas, and some of them may be with Australian partner who can be permanent resident or Australian citizen, but there are also other options for those who are in relationship with New Zealanders or any other visa holders. So that's going to be the topic of my discussion. So let's begin. My name is Yulia Moiseeva, and I'm registered migration agent. I work and live on the Gold Coast, Queensland, Australia. And as I said, today I will be talking about partner visas and all the surrounding questions of this topic. I had a few questions posted to me prior to this live session. And if anyone would like anything to be clarified, I'm very happy to attend those questions after my mini lecture about partner visas. So let's begin. Partner visas, I would say standard scenario can be with Australian citizen or Australian permanent resident or person who are eligible New Zealand citizen. So usually those people are New Zealand citizens who were in Australia on a certain time and date. And then you need to double check whether these people can in fact be sponsors for standard partner pathway. Usually we request movement record in order to double check the dates when eligible New Zealand citizen lived in Australia or were in Australia. And out of these three potential options, so Australian permanent resident, Australian citizen, and eligible New Zealand citizen, you may think and consider three options. Prospective marriage visa, subclass 300, where there are less, I would say, evidence of your relationship at the beginning. And to absolute minimum, yourself and the sponsor must meet at least once in person and must have these documents of meeting each other in person. Then you will be planning your wedding and you're going to be confirming to the department that yourself and your sponsor will be able to become a couple in the future. So for the purpose of prospective marriage visa, you don't have to provide a lot of evidence at the lodgement of visa application. However, you will have to make sure that you have this piece of evidence face-to-face meeting, because some people don't like taking the pictures together or any other reasons. And we had this scenario when we used a lot of alternative documents to basically confirm that two people were at the same time at the same place. So that's very painful. So a humble picture together, and obviously depends when and where you took this picture. It can be tickets, hotel booking, visas to the same place. So this is a minimum amount of documents you would need. So for prospective marriage visa, there is a catch for yourself and sponsor to get married within the validity of 300 visa once it's granted. Usually, this visa can be granted for up to 15 months, so you will have a lot of time to get to know each other and live in Australia together. So this type of visa usually is used for people who meeting somewhere in the third country and they cannot physically live with each other for longer. Therefore, that's the exact and perfect visa option for these scenarios. So after 300 visa holder come to Australia, there will be unlimited full work rights. There will not be access to Medicare on 300 visa, so you will need to be mindful on health insurance. And then the transition to partner visa at the discounted government fee will be after you and your sponsor got married. And then you apply for partner visa based on marriage. And after application is made, you will wait for another 2 years to transfer yourself to permanent residency if the relationship stays. So that's the usual pathway. For the overall assessment and lodgements, I would say you should consider around 3-4 years in total, from 300 visa preparation time until the time you will get permanent residency. So it's fairly lengthy process. Option number 2, for example, you met with the same person, Australian citizen, permanent resident, or eligible New Zealand citizen, but you are able to live together overseas as a couple. So that can be potentially offshore partner visa, where yourself and your sponsor will be residing outside of Australia. You may have 2 options how to prove your relationship. It can be 12 months of living together with evidence of your joint financial, social life, etc. Or it can be less than 12 months living together, but with a proper marriage. In this case, if you're going to be applying for partner visa offshore, you have to make sure that at time of application, you will provide extensive evidence of your already going relationship. So you cannot apply for partner visa saying we will be partners in the future. That's not going to be assessed positively, and you likely will lose your application. So you need to prepare all the evidence at time of lodgement, and then likely this type of visa will be assessed for 12, 18 and more months. So prepare to keep living overseas, because otherwise you will have to figure out any other ways to come to Australia and wait for the decision. So this type of visa is fairly lengthy, and because you're living overseas, my perception why it takes so long, the department may do more further checks, and therefore it all takes time. Option number 3, if again you get to know the person who is Australian citizen, permanent resident, or eligible New Zealand citizen, and they will be heading back to Australia, for example, after short holidays where you spend some time together and you would like to come with them, the wise idea would be to consider visitor visa in order to travel with that person together back to Australia for a short holiday, then get to know each other to see whether you will be capable of running your household together as a couple. And after you're satisfied with all that, you can potentially consider partner visa 820 subclass in order to lodge it from Australia based on either 1 year of de facto relationship where you will be confirming that you've been living together for 12 months. So, of course, visitor visa will not serve the purpose, but there are a variety of other visas, and depends on your country of passport. You may consider working holiday visa or student visa if you were not in a relationship at that time, but then to become partners while you study. So there are a variety of ways how to achieve 12 months of living together. Alternatively, and depends on the state and territory where your sponsor will reside, there are options to either get married or to get de facto registration from the authority, similar where you're getting married, but apply for de facto registration and use that as a discount to get your 12 months cohabitation period for less. So there is no absolute minimum how many weeks or months you need to be together if you either married or in the registered de facto relationship. However, please be mindful again that at the time of lodgement of your partner visa, you have to prepare a lot of comprehensive evidence of your already ongoing relationship. So it needs to be evidence that you live together, that you share your bills together, that you share your financial responsibility together, you have social life together. So it's a lot of evidence you will have to prepare. Hence, it's not possible to prepare good package of documents within a couple of weeks. So it's simply not possible. Therefore, absolute minimum, it's around 2.5 months when person is coming in Australia, say on the visitor visa, and they will be residing with their sponsor at the eligible location. For example, Queensland, New South Wales, Victoria, those states are permitting de facto registration for migration purpose. We will be able to provide the full list of states where the de facto registration is available under this video. So you need to be mindful, what are you going to be doing if you register in de facto relationship or you're going to get married. Also be mindful that department is very cautious on people who are getting married super quick, and it may raise concerns whether the relationship is in fact legitimate, and department at any point may schedule the interview usually with the applicant, and sometimes with applicant and the sponsor if they believe that the relationship are likely not genuine or something doesn't add up. So be careful on rushing into a relationship and then rushing into lodgement of partner visa, because if it's this very short period of time where you pretty much get to know each other and straight away getting into marriage, department will likely be holding this application for longer periods of time to just check that the relationship actually stays. Or they may, as I said, schedule the interview with either applicant or applicant sponsor and then ask more questions about evidence of your relationship. So in terms of who can be the sponsor, apart from status of the sponsor, either Australian permanent resident, Australian citizen, or eligible New Zealand citizen, please be mindful there are limitations. First of all, the sponsorship is only permitted for 2 partners throughout the sponsor lifetime, unless concession and exception applies. But usually, do not forget to ask your partner whether they sponsor anyone before. We had a few scenarios when the sponsorship happened so long ago and the sponsor may genuinely forgot, or obviously if something happened in the past and then sponsor and previous applicant parted not on the good terms, the sponsor may be reluctant to disclose. But it's very important, because if it happened more than 2 times in the past for the sponsor and there is no compassionate, compelling, or other exceptional reason to approve the 3rd sponsorship, again, you may have a risk to lose your visa application and government fees. In terms of other limitations for the sponsor, be mindful that the sponsor will have to provide evidence of police clearances for each and every country where the sponsor resided for more than 12 months in the past 10 years. So if sponsor lived extensively overseas, they will have to provide police clearances from overseas as well as from Australia. And be mindful, because some of the offenses may be harmful for sponsorship to be approved. So it really depends what sort of problems the sponsor has or had in the past. You need to apply and get Australian Federal Police clearance. For that purpose, you only need online application. And then obviously you will have the full picture, because Australian Federal Police clearance certificate will contain absolutely every single offense that ever happened to that person. And sometimes, especially if people were really active in the past in teenage time, they may have a lot of minor offenses. Again, needs to check what's going on. If that's a driving fines, something minor, it will not influence the sponsorship. However, if it's something major, like offenses related to domestic violence or imprisonment, that's where it gets tricky. And again, possibility of sponsorship may be slim. In terms of status of the sponsor, be mindful that if the person was sponsored as a partner, they will have limitation as well to be a sponsor for themselves. If the person received contributory parent visa, there are limitations as well. And if the person has woman at risk visa, there is also a limitation for 5 years since the time it was sponsorship or since the time the person got the visa. So be mindful on that while you're going to be preparing your application. Let's talk about the other possible scenarios. Who else can apply for variety of different partner visas? And at the end, I will be talking about evidence more extensively. So in terms of other options with partners, as I said, it can be an option where you met New Zealand citizen who cannot satisfy and be eligible to be a sponsor for 300 visa, 820 or 309 visas. Then there is still opportunity to have a partner visa with New Zealand citizen. However, this visa will not lead directly to permanent residence. This visa is subclass 461. For this visa, it's 5-year visa where you still have to show evidence of relationship. So it's there is no option of prospective marriage visa. So you have to be partners at time of application for 461 visa. To repeat, what may be the option? You might be residing overseas 12 months together, or you might register your marriage overseas and reside less than 12 months. Or you might come to Australia and lived with your New Zealand partner for 12 months or less with either marriage or eligible registration or de facto relationship. So the same story. However, at time of application, you need to make sure you satisfy every criteria to confirm that you are already a couple. That's important. 5-year visa will allow applicant who is a partner of New Zealand citizen to work in Australia unlimited. So there is no limitation on that visa. You will not have access to Medicare. As I said, you will not have pathway to permanent residency as such. Interestingly enough, this visa can be extended even when the relationship with New Zealand citizen ended. However, there is a catch. The applicant cannot be in any other relationship. So, for example, if you spend 5 years, then your relationship with New Zealand citizen ended, then you can potentially apply for extension to get another 5 years of 461 visa if you're not in a relationship with any other person. So this visa can be potentially extended several times. So you need to make sure if that happens, what's going to be your pathway to permanent residency eventually, because it's only a temporary visa. Then, interestingly, and recently I have this observation, a lot of people in Australia who are residing in Australia may find partners overseas, and those people who are in Australia may be on a variety of different visas. For example, it can be student visas, graduate visas, employed sponsored temporary visas. So a lot of different visas, and those people may meet somebody while in Australia, or they may meet a person from overseas. And then the question is how to bring that person and how to make this person to be a partner on any other visa. So that's also an opportunity. In this case, again, the same criteria applicable. So you either live together for 12 months, or you can be married and live together less than 12 months. Or if you're in Australia, or if only your partner is in Australia and you're overseas, you can get the de facto registration from Australia and prove less than 12 months of living together. So all these possibilities are applicable. And for example, if you build your case, then your partner is likely going to be applying for subsequent entrant visa of the same subclass you have. So it's not going to be a partner visa as such. However, because this person will become a partner, and for the sponsor, it's not going to be a standard case. So it's going to be any other visa. So this person will be applying for subsequent entrant to be with the same subclass of the visa as the partner in Australia. That's interesting trend, and we've done a few application like this successfully. If you are already in Australia, for example, yourself on a temporary visa, and you got to know a person who is also on temporary visa, what to do then? It's not necessarily the case where you have to jump on each other's visa. It's a case of strategic planning. Which one of you may get to permanent residency quicker, and then at what point your partner will be joining you with that application. So it may be a variety of scenarios, and sometimes you may carry on with relationships still being on the different visas for time being. And then you will decide when exactly you kind of combine your application and apply for any other visa together. So let's talk about evidence of partner relationship, because that's very, very important. And I've seen a few of rejections when people are losing over $9,000 because classic partner visa is the visa of the highest price to apply, though a lot of people think it's fairly easy visa, I would say. I would agree and disagree at the same time. Yes, this visa does not require English language. There is no age threshold at all for partner visas. However, you need to make sure you satisfy certain criteria at lodgement. And again, simple as that, if you cannot satisfy criteria at lodgement, you can still lodge the application, but then department will be processing this application longer. And the end of that, if you still will not be able to satisfy the criteria, the application is likely to be refused. So the most important is evidence of relationship. Let's talk about classic scenarios, so-called 4 pillars of the relationship, because as I said, for 300 visa is a minimum relationship, and you provided to the department the evidence that you're gonna be couple in the future. Where for classic partner visas, you need to make sure that you prepare all your evidence for every single pillar to be satisfied at time of application. So let's have a further look. First of all, living together evidence. Fairly simple. However, sometimes people are not on the leases. Sometimes people are living with parents or friends, subletting. So that's not a problem as long as you can prove that you are, in fact, living together at the same address. So simple evidence is lease agreement. Then if you are renting or living without lease agreement, it can be statutory declaration from the owner of the property. Then it has to be some sort of bills coming to your name, not necessarily both of names, at least one name and the address where you're living together. For example, you can show bank statements, you can show any insurances, your mobile phone bill, any subscriptions, deliveries, physical deliveries to your residential address, Uber Eats, Amazon, anything. Then another simple way to show evidence that you're residing together at the same address is your ID documents. For example, Australian driver's license, or in the absence of driver's license can be ID card, student card, any sort of card that will contain your residential address. So that's for living together. And as I said, if you don't have bills as much, there still can be an evidence of some sort of subscription. Or if you have pets, you may have pets insurance, pets ownership, car insurance, some sort of memberships that all will satisfy the criteria of living together and running the household together. Then another major criteria is your financial situation. Every couple will run their financials individually, so it's up to applicant and then sponsor to decide which way, how you're going to run the financials in your own household. However, you will have to prove it to department that you are in fact getting joint decisions on your financials, and you run your household as a couple. In this case, again, the simple scenario will be to open and actively use bank account. So do not open bank account that will not never going to be used, because that is zero evidence pretty much. You can open bank account to pile a little bit of money from the sponsor and the applicant side towards any future purchases. You can potentially run two bank accounts together. However, you will have to show that how you reciprocate your expenses. For example, somebody paying for one, the other paying for the other. And again, you will have to show evidence of your bank statements. One of the crucial, I would say, evidence for future of the couple is superannuation, and you may consider adding your partner in the superannuation as a beneficiary. In this case, that's more complex area, and I would recommend to seek legal advice if that's something you would do in terms of your future planning. And then you can choose any percentage you can appoint to your partner in terms of beneficiary on your superannuation. Why it is important? Because in case of death or anything happen to the sponsor, the applicant will be entitled, according to percentage given, to any superannuation guarantee or anything that's attached to that. And it's important for department to understand that that's a long-term planning and long-term financial commitment. But very important thing. Another important thing is a will. But if you are 20-year-old and you're arranging will for yourself and the partner, it's really looking suspicious in terms of you just piling any documents to please a department rather than to show your genuine relationship. So it really depends at what stage of relationship are you, at what age are you, I would say. For more mature couples, the arranging the will, it's going to be logical. For more younger couple, arranging the will, it's going to be not natural, I would say. Then the next section is social life. So usually you're going to be attending any events with your family, friends, anything, going somewhere, having a membership somewhere, having invitation to any of family and friends gathering. So everything will be piled in section. Your joint travel, your joint photos. So a lot of evidence can be piled in this section. Also, one of the evidence is your communication. You can think about the option to get evidence of your calls to each other in the form of phone bill or any history of your calls to each other in the past. Or alternatively, you can think about providing department with messages history. In this case, be really mindful what are you providing, because department will be reading. And there is no requirement to provide anything super personal, absolutely not. But in this case, you need to be mindful whether your messages history will in fact reflect that you are in the de facto relationship, or you're more at boyfriend-girlfriend stage. Be mindful on that. Because, for example, huge evidence is when you texting each other after work and say, hey, let's meet somewhere for a drink, for a meal, you have a good time, and then you're going home to each other's places and you're not sleeping together, in one bedroom where you have toothbrush in the toilet. Another piece of evidence that will likely satisfy the department in terms of de facto relationship, where you're calling or texting each other after work and saying, look, let's meet for a drink, you'll have a good time, but you're going to be coming home together. Or you're going to be texting each other saying, look, I'm coming back home, would you like a takeaway? Or what's going to be for dinner? I can go through shops, etc., etc. So it's a bit different angle, and it's really seen on the messages at what stage of relationship you may be. So be mindful on that. The other evidence of relationship is your commitment, and in this specific section, you will have to consider writing a story about your relationship. So it's going to be one story from applicant and one story for a sponsor. In this case, you cannot copy paste and cheat and provide one story for both of you. So of course it's gonna have similar facts, similar dates, but the delivery will be a bit different. So department would like to see your side of the story pretty much. And in this case, I usually consider and provide the advice for the applicant and the sponsor to think about some sort of situations where you, for example, support each other mentally, physically, financially. You struggle and then you succeeded, or you were in a good situation, a good place together. So a bit of personal touch on the stories will be definitely better off, because if you're going to be just stating the facts with no romance, again, it looks really bad and suspicious to the department that you may have no feelings towards each other. So you need to be careful about that. Also, be mindful that department may look at the social media accounts. So what's happening there, you don't have to have social media accounts, or you don't have to post anything about each other, but you just need to be mindful whether if you have any information on your socials, whether it's actually match what you're saying on your visa application and on your statements. Because as I said, department takes time to process this visa. Also, they may have a look at social media profiles and then investigate further if something does not match. So in terms of the pathways and the timing, as I said, if we're talking about 300 visas, 309 partner visa, 820 visa, so all of these visas may likely be processed within a year from lodgement. Then partner visa first stage will be converted in the partner visa permanent 2 years after the original lodgement. And when you apply for permanent residency, providing further evidence that you are still in relationship with your partner. Be mindful that when you apply for partner visa, my advice is to keep collecting the evidence of relationship and upload the new evidence of relationship at least every 3 months while you're waiting on the visa. The reason for that is just to keep the file fresh, because if it's been, say, a year since lodgement and there is no further evidence on the file, the department will likely request the new evidence to basically confirm whether you are in fact in the relationship or not. Please bear in mind that sponsor has a right to withdraw their sponsorship, especially if the relationship are ending or you are in conflict or relationship already ended. When the sponsor will do that, the visa applicant will receive correspondence from the department to basically confirm how and when the relationship ended. And usually, if the relationship ended peacefully and there was no child in common involved and no domestic violence involved, you will lose your visa application. You will not be able to proceed any further. The reason for that is simple, because for partner visa, you will have to be in relationship with the partner. So if there is any domestic violence going on, just a reminder that we in Australia have a lot of support for domestic violence victims. And in every state and territory, there are free organizations that will provide not only information and support for domestic violence victims, but also those organizations will likely provide free visa support. So I usually refer any clients who are suffering from domestic violence straight to those organizations, and you can simply Google those and find those organizations closer to you if you have any problems with your relationship and you need to clarify your rights. So the best case is to start with appointment with this organization to understand what's going on and how they can help you. So don't underestimate the help, because Australia is a country who are not tolerating domestic violence. And be mindful if something is going on. My best advice is not to leave it till last minute, but book an appointment and double check whether you're safe and what can you do with the situation. So we're finishing with my lecture part for partner visas. So let me read the questions that I have already sent to me prior to my live, and then I will address those questions. And if anyone would like to clarify any questions you may have, feel free to post in the chat. So please let me know if I can get the tourist visa, then come to Australia and then apply for partner visa or de facto visa. If that's possible, what can be an obstacles and timeline for those visas, including tourist visa? My boyfriend is a citizen of Australia. We are together for 7 years, and we would like to travel to Sydney after 2 months of our traveling somewhere overseas in February 2025. I've never been in Australia before. So in this scenario, I would say it's going to be really appropriate to consider visitor visa, but bear in mind that you will have to disclose your relationship on the visitor visa. And a lot of advisors, especially overseas advisors, and a lot of clients think that if they disclose their relationship, that it's 100% going to be visa refusal. Don't do that. Department would like transparency, and there is no criteria where visitor visa will simply be refused because on the fact that you have an Australian partner. So you have to disclose your relationship, but then you still have to satisfy the requirement for visitor visa, so ties to home country. You can rewatch my other video about visitor visas. So yeah, that's important. And you don't need to apply for sponsored visitor visa, because you will not be able then to progress to partner visa onshore. So be mindful, you will have to apply for visitor visa tourist stream. And I would recommend no more than 3 months stay. Otherwise, department again may not like the idea and the application may be refused. If you get the visa, you will have to double check the criteria and your conditions on the visa. And depends if you're going to be residing in New South Wales, you can register your de facto relationship and then apply for partner visa based on de facto relationship and evidence that you live together for at least 2.5 months, running your household and being a de facto couple. If you are in relationship for 7 years, living together somewhere overseas, you can prove at least 3 years of your de facto relationship overseas, and department may consider temporary and permanent visa on the same application. So that's important. So do not only provide evidence of 2.5 months if you have more. However, if you was 7 years on online relationship, just being in online relationship will not be considered as de facto relationship as such. Let's have a look at another question. How long after divorce does someone need to wait to apply to come to Australia on a partner visa? It depends what sort of partner visa we are talking about. If we're talking about 300 visa, prospective marriage, then the person, both applicant and sponsor, would have to be divorced and free to get married again. If we're talking about partner visa based on de facto relationship, you can get divorced first. Then from the same from the example just before, you can come to Australia and get de facto registration, because if the person is not divorced, de facto registration will not happen. So you need to get divorced first. Or I had a couple where neither applicant nor a sponsor were divorced, and we applied purely based on 12 months evidence of living together, and this application was successful. So if that's your case, you may not need to get divorced, but it really depends how long you were in relationship and what sort of visa you're going to be applying for. Right, let's have a look at another question. Relationship ended in 2023 when the applicant was on temporary partner visa. She went back offshore, and department gave her permanent residency September 2024. How's that possible? That's a question from the sponsor. If we didn't do anything for a supposed to be stage 2 application, which is permanent residence submission, interview, etc., did she use some not very nice ways to get it? Report me as an abuser. Do I need to worry on my end? So first of all, when a relationship ended, did you report those relationship end to the department or not? Because if you never, I had this scenario where a partner visa permanent stage was granted without any application. So we started preparing the application for one of my clients, and the visa was just randomly granted. So that would be maybe the case. However, if you notify the department that relationship ended, and if you would like to clear up from your end, I would contact the department and request explanation from your side as a sponsor. And if there was any administrative error, but potential is there that you may be responsible for this person to lose the permanent residency if the decision was made when you were not in relationship and this was declared to the department. However, as you mentioned, it may be another ways of reporting the domestic violence and then proceeding through that pathway, because if the person claims the domestic violence, you as a sponsor will never be contacted by the department to check whether it was true or not. The department will be looking at evidence that the applicant will provide solely. So that's an unfortunate situation. Right, another one. I'm in a relationship with Australian permanent residency holder for more than 3 years. So straight away, the question is what sort of relationship? If it's only online relationship, for the purpose of partner visa, it will not be considered as relationship. So it needs to be physical living together. I have 2 children from a previous marriage. We are planning to apply for prospective marriage, but firstly, we would like to visit Australia. That's an absolute good scenario where you're coming to visit your partner to basically understand how and where he or she lives to make your decision whether you would like to migrate. Can I include my children in the application so they will get the visitor visa as well? We're planning to come to Australia on the visitor visas and then apply for prospective marriage visa. So the question is, about the logistics of that. Because prospective marriage visa has to be made, the application has to be made where the applicant is overseas. So you cannot apply for prospective marriage visa from Australia. That's the first one. In regards to including your children in the application, first, you need to seek consent from the biological father of the children or using the form 1229, unless you have a full sole custody. And your children must be either under 18, or if they are over 18 and under 22, they will have to be financially dependent on you. So it's important. Talking about timing and applications. So visitor visa, every single applicant will apply in their own application, even children. And then you will have to combine these applications in the group. That's how they're going to be linked together. If you get your visitor visa and if your partner resides somewhere in Australia where de facto registration is permitted and you would like to permitted for migration purpose, and you would like to come on a visitor visa and possibly stay and apply for partner visa based on de facto registration, de facto relationship, you can use this pathway instead of visiting Australia, then going overseas, and then applying for prospective marriage visa and using visitor visa to just come and go because it's going to be too expensive for you and the children. Bear that in mind. If you're going to be coming to Australia on a visitor visa and then waiting for partner visa with children, school age children, or any children who will have to study, you will be paying for the study full price. So be mindful on that as well. And another question. Question about how much evidence you need to provide. For example, if it's a minimum 2 letters, does it need to be 5 or more? So my advice is just to make it the way you live together. So if it's a couple of people who know about your relationship and you do not socialize as much, that's fine, but do not produce extensive evidence of unnecessary documents that department may think that you're just doing it for the purpose of securing the visa. So it needs to be logic. You don't have to file 20 statements. So minimum is 2 from family and friends. And then I would suggest to start with close family circle and then move to friends to basically confirm with department that your friends and family accept you as a couple. If and when I apply from Australia and they receive bridging visa, can I work and will I become a tax resident? So this question is not for me because I'm not an accountant. However, because depending on where is your income coming from, you may not become a tax resident. However, on bridging visa, you will have full work rights, and then you will likely be considering professional advice from accountant as a starting point. If when I apply for tourist visa, I have my surname and mom's name, but in a birth certificate, they're different because my mom was married and divorced. The question is whether the department will be looking at additional documents of marriage, divorce, and birth certificate to prove our family ties. The question is yes. So for partner visa, if the person been married, divorced, and changed names several times, every single change of name will have to be proven by documents. So that's absolutely correct. So that's all I have for today. Thank you very much for attending the webinar. Thank you very much for listening. So we will post this video, and you will be able to rewatch it if needed. And we will post useful links as well, everything I mentioned during my live. Thank you very much, and have a lovely Sunday. Bye.